I've invited you to this press conference as ambassador and permanent representative of the Republic of Equatorial Guinea to the United Nations to condemn and to reject the judgment that was carried out in Paris, delivered in Paris, of the 19th of June to the 6th of July this year against His Excellency, the Vice President of the Republic of Equatorial Guinea, Don Teodoro Mangue, in the supposed case that is called ill-acquired assets. It's very clearly a political plot which was led by Transparency International France with the complicity of Mr. William Bourdon and Mr. Levesque, all of them with interests in the Republic of Equatorial Guinea who were not able to be part of the oil business. Then they have brought together this plot with the objective of destabilizing the regime so that they could achieve their objectives in this way. As witnesses to this false political trial, Transparency International France resorted to elements such as Badade, who was sentenced in Equatorial Guinea in 2013 and in Cameroon in 2014. And a group of opponents to the regime, such as Brother Herman Pirontomo and others, all of them who are well recognized as elements who have obstructed, who have tried to bring about change in the regime of the country, such as the failed attempt of the mercenary invasion of 2004, as was declared by Mr. Simon Mann during the trial. In order to try to provide a legal cover to the trial, they resorted to correct an association that involved several opposition non-legal political parties and who are based on the outside, who were designated as a civil party to the trial, when we know that the French Penal Code only recognizes a particular party when its existence is longer than 5 years. Correct was created in 2015. It's only been around for 2 years, and that shows that their participation is invalid, and their objective was only to obtain funds for their political activities. But due to the poor distribution of these funds among the members, it was a shameful public ruckus. As a result, journalists, Mr. Levesque and Mr. Bourdon and Transparency International France, all of them with economic interests in Equatorial Guinea, a conglomerate as well as a group of non-legal political parties, they cannot be part of a trial against a senior official in Guinea-Bissau. With the request for 30 million euros in penalty and the seizure of all of the goods, including the diplomatic mission, the French justice did not respect the decision of the International Court of Justice. And in fact, they should have waited for the announcement of the International Court of Justice, as well as the immunity that protects the Vice President. In short, both the Correctional Court of Paris, as well as the judge of first instance who presided over the trial, they're not qualified, nor are they apted to judge a vice president of the Republic. It has been a criminal trial without victims, because in the case of a killing, there has to be a corpse. But in the case that we're dealing with, since there are no victims, they decided to resort to correct an association of political parties in exile to whom the French justice attributes the power to recognize them as legitimate representatives of the people of Equatorial Guinea. But as we've already pointed out, they are not a valid party. And lastly, the decision on the precautionary measures of the International Court of Justice compels French courts to take no decision until that legal authority of the United Nations has spoken out on the substance of the matter. French courts under the instigation of Transparency International France, and the group is going against the Vice President of the Republic of Equatorial Guinea. They are charging them with supposed crimes that were committed in Equatorial Guinea. Its perpetrator and national of Equatorial Guinea, and the victims is also from Equatorial Guinea. But the principle of territoriality and sovereignty attributes the competence to the courts of Equatorial Guinea, for whom there was no and has never been any crime. The French justice is not qualified in this case, and all of their actions have been null and void. Therefore, I declare that this trial is not valid, and I condemn before the international community the maneuvers to destabilize the political regime of the Republic of Equatorial Guinea by some elements with hidden interests in the country, and linked to some of the promoters of the mercenary attempt against our country. This false trial is just a plan B to try to achieve the objectives that they couldn't achieve in 2004, which are to take over the resources of the Republic of Equatorial Guinea. Now, from the headquarters of the United Nations, I call upon the international community to put an end to these maneuvers that aim to undermine peace and sustainable development that are enjoyed by the people of Equatorial